I don't at all. I'm diametrically opposed to what Leonard Sylvia Kuje is saying.
Why is that?
Totally opposed to it. It's this matter, more or less, the same question of Article 296 C has been to the Supreme Court, where Amegache versus EC, or no, even the France. Okay, there is France, Transport France versus EC, where the argument was made that because the EC hadn't published regulations on how they will exercise their discretion, then it means that the elections that were sought to be held, I think that was 2012, will be null and void. That Ivan said that, hey, to give Saka to oppose such an argument will lead to a nuclear meltdown. Nuclear meltdown. That was 2012. Now, ask yourself, from 2012, what regulations have EC brought? All the other constitutional bodies, what have they done? Right? You even look at AJ Chum versus Attorney General. So for Kufu and the rest of the bench, when I say AJ Chum versus Attorney General, a case concerning Article 146 proceedings, they said the rules of court committee should come out with fuller regulations, rules that will make the process more streamlined, etc. AJ Chum versus Attorney General was about 20 years ago, 2005, 2006. Okay? Till date, it's not been done. About 20 years ago, that's not been done, right? So the Supreme Court has said that the failure to publish the rules as stated in 296 doesn't make the exercise void. It doesn't at all. It doesn't. So let's not kid ourselves. It doesn't make what the president is doing void. It doesn't make it unconstitutional, because the Supreme Court itself has realized that if they were to say so, then society will grind to a halt. So the Supreme Court said there would be a nuclear meltdown. Nuclear meltdown, if you want to say that, for all the public officers who have to exercise their discretion, there must be published regulations and statutory instruments before they do it. So the Supreme Court has answered it. So let's go on, except that as citizens, of course, we have a fair sense of what is justice. If we see something untoward, we'll raise it. The president knows that Ghanaians will not sit down unconcerned. So we are watching. But I think it's far-fetched to say that what is going on or the suspension is unconstitutional. I think that that argument doesn't, there's no merit in that argument at all.
Well, that's what they're saying, that the president should revoke the said suspension on the basis of the argument that it is unconstitutional because 296 was not considered.
That's why I said, so my simple answer is that that answer was given in Ransford, France versus Attorney General, then Parliament. They raised the same thing, that the EC hadn't published regulations on how they will exercise their discretions, etc. And so even we should stop the elections, etc. The Supreme Court said, no, that is not law. That is not law. So this one, I beg to differ from the GBA, my own GBA. And it's curious that the GBA has finally found his voice and is coming here. When the Akufo-Addo was misgoverning, we were talking, they were quiet, you see? So it tells you that it's interesting that President Mahama is a better president, he's more accommodating, so now the GBA can wade into such controversial matters. When the Akufo-Addo was misgoverning, corruption was at its peak, okay, family and friends, we were on radio, TV, the key points. GBA stood and said, no, they don't want to be involved in such matters. But now that GM is president, they know that he's more tolerant. So for him, they can come and then wade in and make all their arguments. Please, you've seen how our citizens have become very savvy. They've told GBA in no uncertain terms that they are not the conscience of the nation. They lost that position years ago. It's okay, they've come to talk, but they should realize that they lack that authority that they had decades ago.